It can testify as to what happened, but he can't get up here and tell this jury that there is some reason for them to decide one way or the other because of that conversation, because that's what Gibbs is saying. We can't do that because there's a reason for the provocation instruction in this particular justifiable use of deadly force. But you can't go beyond that provocation and now start thinking that, well, any word that was said between these two gentlemen somehow has some relevance and some significance. In this case, it does not. And this case is directly on point. It's cited in the jury instruction. I would ask the court to follow it, because otherwise, it is, you saw what they did in Gibbs. It was reversed. And so we can't have that here. We've spent way too much time.
Thank you for that reminder. I'm well aware of how much time we've spent. So, again, you keep saying that these activities are completely irrelevant. How do you answer Mr. Martin's argument that that would leave kind of a vacuum?
Judge, the witnesses are going to testify about what happened. What I am concerned about is not that the witnesses are going to testify about what happened. What I am concerned is that in opening statements today, they're going to make this argument that somehow, if you watch and see, if the court, denies me, they're going to get up there and they're going to say, Mr. Reeves should have never engaged Mr. Oulson, which is exactly what this court is saying you can't do, because that's the issue of provocation. You can call it provocation, you can call it rekindle, you can call hostility, you can call it whatever you want to call it. It's still provocation. And we can't have that in this particular case. Now, are the witnesses going to be able to say that, hey, listen, when Mr. Reeves came back in, Mr. Oulson, made that statement, or what if they even don't say that? Let's assume that, they don't have that. Mr. Reeves came back and said, oh, I see that you put your phone away. That's perfectly fine. I'm not going to object to that, because those are facts, as to what happened there. The danger here is how they use that. How they use that to this jury, because they know that it has absolutely no issue with reference to this case.
The facts, as Mr. Escobar stated them, are almost exactly true. The defendant was the one, based on his own statement. I mean, you're going to hear from witnesses, but the defendant's own statement was, when he came back from the manager, he initiated a contact with Chad Oulson. We are not going to be arguing anything different than the jury instruction. We're not going to try to put any facts out there or apply the facts to the law, as the law does not exist. We're not doing that. But the facts are certainly relevant, and I think that the court's obviously indicating that it is. But we are not going to be arguing this case any way different than what the law allows.
Give me an example. Do you have an example?
When Mr. Reeves came back from the manager, as he's walking down the row, or when he sits down, or immediately thereafter, he initiates a conversation with Chad Oulson. At that time, he says to him words to the effect of, I see you put your phone away, I went to the manager for no reason. It's at that point in time that Chad Oulson turns around in his seat. I mean, that's basically exactly what I'm going to say.
Okay.
Judge, if that's all he says, then I'm not concerned about it. But I am concerned if he says anything about fault in what Kindle was.
All right.
That'll probably be more closing than opening.
Right.
And we are allowed to draw whatever inferences the facts.
All right. So we're clear on openings. We can get started. I'll look a little closer at this case, and I'll make my final decision as to the jury instruction when we're at a break or something, when we're discussing other matters. Anything else that we need to address this morning?
Yes, Your Honor, unfortunately. I was told this morning that the exhibits that Mr. Martin had told me were going to be played in opening statements. They're not going to play those exhibits now. They're going to be playing some ABI exhibits. And if the court recalls the conversation that we had Friday concerning these videos, some of them have blue screens or black screens that show up when the video is not recording. And we talked about some videos that actually have the last frame that is recorded, and it stays in that last frame while it's not recording. And Mr. Martin, and I can get the transcript, Mr. Martin himself agreed that that particular type of video was certainly a video that would suggest to the court something that the evidence isn't, meaning that frame stays. and the jury gets the impression that that's the recording, and when it's not, that it's misleading. He said that Friday, he agreed with that Friday. Today he wants to introduce that, and so we would object. We think it's misleading. There is absolutely no reason that we need to introduce anything that's misleading to this jury.
Mr. Murray?
In this particular case, there's the first exhibit is the native video that was downloaded by the IT at Cobb, given to Fred Myers and given to the sheriff's office. Later on, we got the hard drive. Our experts determined that what was on this USB hard drive that you stick in the computer and the hard drive were in fact the same. Now, what was downloaded on the 15th is known as a recorded video. It is the native video right out of the DVR. There is no blue screens. It runs continually, and it's the native video. From the hard drive, we exported not only the recorded video, which is just the recorded video it goes from back to back. Then you have a real-time video where the DVR software itself actually inserted the blue screens to show where there was no recording. I haven't even received all of the new exhibits from the defense today. I received some over the weekend after reviewing what their expert has redone, which I haven't been able to talk to him about. No, I got them. I watched them. Once I watched them and discussed it with my expert, it's important for the jury to know what the native raw data is. And that's the reason today, at the beginning, I will play the native raw data off that flash drive. I already have it preloaded on the whiteboard. Right after that, I will play the native raw data in which the blue screens were inserted on all three cameras. So they'll see the native raw data real time, that it's just straight, and then immediately after will be the blue screen. And we will use the blue screens with our witnesses. The first exhibit will be used either with my witness or with in my cross of their witness, but we are going to be playing it, and I think because of what Mr. Escobar handed me over the weekend, I have no choice but to let the jury see what is an absolute, no enhancement, no nothing, no one's manipulated it at all, because the defense exhibits that I have been manipulated to the point that they have to see the raw data. And that's why it's being put on. I'm not going to argue that this timely. It's just, we're going to play one after another. And it's almost like any type of enhancer. You put in the original first, then you put in the blue screens. That's what we're doing, back to back.
Judge, if I may, because I want to clear this record, I'm going to show you what's given to me by the prosecution, which is the raw data. They went through great lengths with Emily to put the raw data and use it with the deal version. There's a second. We've got two of these. Two Transcend thumb drives. They went through a great deal of work with Emily in order to get the raw data to play on the GeoVision software, which was the software that was in the DVR at the theater. This is raw data. For him to say now that he has to play this other video because it's raw data is not correct, and it's not true. This is raw data. This is GeoVision. I think that the reason, frankly, now that they're switching horses and they don't want to play this one is because ours is I think, a much clearer portrayal of the actual video. And let me tell you what we did. Ours is very simple. If we had a screen of the video this big, we used nearest neighbor, and we made it this big. That's it. don't even cover the entire screen. You know why? Because there's a mathematical formula that you have, it's gotta be a square. If you go beyond a square, you're using interpolation. And we don't wanna do that. And so ours, the screen doesn't do anything to our videos. Our videos are what they are, and our experts are gonna testify about that. But think about it, we're now introducing a video, which up until this morning, he said he was gonna use this. Now he's gonna use a video that has the last frame continuing to run, as if someone that's looking at it is gonna think, oh, that's what's happening during that period of time. For no reason whatsoever, when he's got the raw video. These are the raw videos, with the GeoVision, which they made such a big deal about that they had to get a GeoVision software to make them operate. To be honest with you, you don't need a GeoVision software to operate these things. We looked at it, we didn't want to do what he did, but I think at this point in time, Your Honor, we're creating, in the eyes of the jury, we're creating something that they're seeing that clearly is misleading. And Judge, I'll be more than glad to get the transcript from Friday where he admitted that it was misleading. And here we are, now he wants to introduce it.
Your Honor, it's the raw data, and then what he showed the court very dramatically, what I gave him, then I'm gonna play those. So it's not misleading. They're gonna see it back to back to back. It's not gonna be misleading. It's just like we would do with our experts. You put on the original raw, then you do the enhancements. It's important that they see what the native video is.
All right,
And so it's not misleading.
now Friday we were talking about raw data, now we're talking native. What's the difference here?
I'm sorry, it's just a term, it's the same.
All right,
It's
so
raw.
the one that you intend to show is the same one that Mr. Escobar is showing?
What he's showing, no, I'm
No,
not.
no. I mean, look, this is
I plan to, that'll be the second video. The first video, which has already been stipulated to previously, back 5 years ago, that whatever, I'm not going to repeat the stipulation, all right. It's already been stipulated. It's coming in. I mean, there's no argument that it's not. He's arguing, well, it's a 403, and I said it's this. I go, yeah, I'm not going to use it with the witnesses. We'll use the other ones, but they need to know what the raw looks like. So I'm going to play that, and then 3 more, right at the beginning before any witness. It's just the unrecorded is not there.
But for time frame, it shows on there that there's a gap. So for example, it would go up to 1 minute, and then it'll start at 1:03. So if you looked at the time, you know there's a 3-minute gap. Just the other video inserts a blue screen. This original video just shows 3 minutes went by. No one in here is going to be arguing anything at all to mislead the jury that it's one continuous set of events. So that's the most important thing.
Judge, take a look at that video, and you tell me whether you can tell that there's 3 minutes that go between one screen and another. You won't be able to. Neither will I, and neither will that jury.
If you want us to, we will argue it. We're not going to mislead the jury.
Then why do we need to show that one? Where did that come from?
It is direct response to the manipulated videos that I was provided by the defense that they're going to put on. They have to know what the video looks like, whether it's a fair and accurate representation of what the DVR produced as opposed to the manipulated DVDs that the defense is going to put on in this case. It's paramount that they see this particular video. They have to. They're going to determine whether or not one set of videos or another is in fact. If I'm precluded from putting on the native raw to show the extreme difference between the other one, then that would be wrong.
All right, and we've talked about that. I insisted that they get to see the original, raw, native, naked, whatever you want to call it, so they can make the decision by themselves. They can be the fact finders that they need to be,
Yes.
and they can give each expert's witness testimony the weight that they think it deserves based on the differences in the videos. And I've said all along since Friday, I haven't seen these videos in many years, and I don't know if we've got new versions, but, you know, all this arguing that we've been doing about these videos, I'm wondering, is there any difference that the jury's gonna see? But
Yes,
that
Judge, and I will tell you.
waits to be seen.
I will tell you what we signed. We had the signed stipulation on exhibits 2 and 3. Is it here? Let me show you what we agreed to this weekend. We spent an enormous amount of time agreeing to on those Transcend thumb drives. Can I approach?
Yes?
It hasn't been signed right now, but we've signed.
All right.
Mr. Reeves has signed it.
I know.
Yeah. And so we spent, now, Judge, if you want to, let me have the Transcend. You can put it on. I want to explain this to you because it's so important. They went through great lengths with Emma to get the raw video with the GeoVision software. That GeoVision software actually puts blue screens when it's not recording. So let's think about that. The GeoVision software that was in the DVRs puts the blue screens when it's not recorded. But he wants to introduce raw data that doesn't do that. Does that make any sense? We went through great lengths, and I agreed. I said, I looked at him, I said, yeah, we'll sign off on it. You know, you can, this morning, he says, we're canceling that. Now we're putting in some AVI that doesn't have those blue screens in between. That is misleading, especially since he agreed on Friday that it was misleading. Here we are arguing about something that, Your Honor, he agreed to on Friday that it was misleading. We can't mislead this jury. And by the way, he says that ours is manipulated. Can you please tell us what we did to manipulate it? I can tell you, ours is
It's okay.
nearest
I
neighbor.
know, nearest neighbor, and I know. We're not gonna go into that again. And theirs is, remind me.
It's by cubic.
By
meter,
cubic,
but
thank
the
you.
bottom line is none of that. And yes, I'm still playing what I told him I was going to play. We're just playing the first one, which the stipulation that we signed many years ago. We all agreed what it was, and I played it right from the beginning of last year.
Did you all stipulate to this years ago?
As far as the one AWS, yes.
Whatever one,
Yes,
the
it was
controversial
stipulated
one
years-
today.
It was stipulated
Your
2
Honor,
years ago.
what we stipulated to was that those were in fact authentic videos. Not that playing it before this jury was going to be appropriate, because I can tell you that we weren't doing that. All of ours have black screens. In between every area, it has black screens, and it actually has a counter on the black screen that you can really read, and you can see, okay, the next screen is coming up in a minute, or the next screen that's being recorded is coming up in 30 seconds. So that the person that's looking at it can say, okay, it's not recording right now, but in 30 seconds we're going to get some more recording. And bingo, the next recording comes up, and then the black screen comes up again. Okay, next recording is going to be in a minute and 30 seconds. And a minute and 30 seconds, bingo, it comes up. It's a very easy process for jurors to understand, and we're not confusing them. And so I would object, Your Honor. What I would ask the court, if for some reason the court rules against us, that particular video that is being played in opening be entered into court's evidence so that we can have it preserved for any future need.
Tell me again, why do you need this different one?
The very first one that we got 2 days afterwards, because that is the raw data that neither expert has touched. The jury needs to see that so that they can, like you said, determine which one they're going to accept. It is extremely different from the experts. And so they're going to have to make the decision. And like I said, we are going to play the other one right behind it. They're not going to be misled. They're going to know that there's gaps. So
All right.
I want to play it
All right,
from the start.
I'm going to allow it. If it's the raw, if it is what it is, then that's what they're going to get to see. Obviously, the next one's going to show the time gaps with, what, yours is blue, and I'm going to allow it. And we'll enter it as a court exhibit.
As a court exhibit?
Yeah.
I'd offer it as state's exhibit number 1.
Well, I mean,
We're not using it in
If
opening.
you've agreed to have it in, then it's going to be in as part of the record. I just want to make sure that that thumb drive stays here with the clerk, because if there's an issue later on, we need to have that preserved as to what was showed.
I have it. I'm going to hand it to the clerk. It's already loaded on the whiteboard, then I'll play it, but it will be offered, admitted. I have it here. It will be in the court file.
so what witness is gonna,
It's solely based on the stipulation. You're
Okay.
going to read that
Okay.
stipulation, then I'm going to play 3 more. So I'll offer it into evidence based on the previous stipulation. It'll be marked, entered. I'll play it on the whiteboard, and then I'll play the next 3, which will be State's Exhibits number 2.
all right, so, how's this gonna work? Am I gonna read a stipulation during opening?
We're not playing a video in open.
Okay,
That's why
okay. I thought that's what this was all about
I
right
think Mr.
now.
Escobar thought that we were gonna play the video in opening. We're not playing the video in opening. It would be at the beginning of the state's case sheet.
Okay,
It'll be
okay, that's
for
why I
any-
couldn't understand, how are you gonna enter it during openings if,
No.
you don't have a witness?
No, it'll be
Okay.
before any witnesses. I'm going to play 4 videos. Based on the stipulations, then we'll put on our first witness.
Okay,
I don't need a witness
to play them, that's correct, but, and you either have to have a stipulation or a witness to
Yes.
enter it,
So
so,
we have the stipulations for those
okay.
videos.
So, just for housekeeping matters, before you play the video, I assume I'm gonna be reading a stipulation.
As far as the first one, we can go back to the one we signed years later.
All right,
We have that. In fact, I'll work on something and with a highlighter, so because it covers so much, and then I'll review it with Mr. Escobar, and then we'll provide it to the court. But I was just going to enter pursuant to previous stipulations, so we didn't have to refer to anything,
okay.
which we all know what it is and occurred.
All right. Anything else we need to address before we get the jury in?
Just signing these orders real quick,
Okay,
and then if you'll, may I approach or may the,
you can come up.
thank you.
These originals are going in the court file?
Well, if
You
you'll
need-
return them to me, I'll make sure everyone gets a copy.
All right.
Or a copy if you have to watch. A copy. Thank you, Your Honor.
All right, so, do we have all the jurors? Awesome. Are we ready?
They're in the deliberation.
Oh, fantastic, good job. All right, are we ready to bring them out?
Yes, Your Honor, we are.
Excellent. All right, so they'll be sworn. I've got a little bit of instruction for them, and then you'll begin openings.
Ready for the jury, Your Honor?
Yes.
Jurors are in the courtroom.
Good morning. Thank you all for returning. Yeah, I need you guys standing for just a moment. You're going to go ahead and take an oath. But were you all able to abide by my instructions during the recess? Nobody did any independent research or looked up anything or watched the news or anything? All right. If you would, please raise your right hands to receive the oath from Madam Clerk.
Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant Curtis Reeves and render a true verdict according to the law and evidence, so help you God?
Okay, you can be seated. Thank you. All right, ladies and gentlemen, and just a housekeeping matter real quick. I know some of you had inquired about a letter that I can get for your employers. How many of you need those? All right, number 2, 3, 4, 10, 9, 8. So, okay, all right, and you'll have those probably at the next break. All right, so I've got a few instructions for you, and then we are gonna move into opening statements. All right, ladies and gentlemen of the jury, you have been selected and sworn as the jury to try the case of State of Florida versus Curtis Reeves. This is a criminal case. Mr. Reeves is charged with second-degree murder and aggravated battery. The definition of the crimes charged will be explained to you later. The state's charging document, which is called the information, and I read that to you earlier last week, is not evidence and is not to be considered by you as any proof of guilt. It is the judge's responsibility to explain the law to you, and it is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Mr. Reeves in accordance with the law that I provide you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Testimony by witnesses is evidence. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, the court will instruct you on the law applicable to the case. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case amongst yourselves. Your verdict must be solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, please notify court personnel immediately. During the course of the trial, the court will take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, Tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the bailiff, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. And the reason for this is we've got microphones all around the courtroom, and even if your phone is on silent and it starts vibrating, it picks up in the microphones. You'll hear it. I'm sure it'll probably happen sometime during this trial. You may use these devices during recesses, but even then you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside the jury room, and you will not have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. But you will leave your cell phones on the table there while you're deliberating. This case must be tried by you only on the evidence presented during the trial, in your presence and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed in the trial. And all of these rules apply throughout the trial. Once you've heard the magic words that you are now discharged from your service as juror, I don't care what you do, any of that stuff, but between now until that time, these rules apply. Jurors must not have any discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face to face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury's service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against him or her, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result that would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted so as to consume as little of your time as is necessary for a fair and orderly trial of the case. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You have been provided with a notepad and a pen for use if you wish to take notes. That's in your envelope there. Any notes that you take will be for your personal use. You will be able to share your notes with your fellow jurors during your deliberations. Not any time other than that, of course, because you're not going to discuss anything amongst yourselves prior to your deliberations. However, you should not take them with you from the courtroom. During recesses, just leave them on your chair and the bailiff will watch over them. After you have completed your deliberations, the bailiff will deliver your notes to me and they will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. At this time, the attorneys will have an opportunity to make opening statements in which they may explain to you the issues in the case and summarize the facts that they expect the evidence to show. After all the evidence has been received, the attorneys will again have the opportunity to address you and make their final arguments. The statements that the attorneys now make and the arguments that they may later make are not to be considered by you either as evidence in the case or as your instruction on the law. Nevertheless, these statements and arguments are intended to help you properly understand the issues, the evidence, and the applicable law. So please give them your close attention. State, Mr. Rosenwasser.
Members of the jury, what you're going to learn during the course of this trial is that back on January 13th of 2014, Chad and Nicole Oulson decided to spend the day together. It was a Monday. They had not been spending that much time together based on their work schedules. They were also raising their daughter Lexi, who at the time was just under 2 years old. So they decided on that day that they were going to put Lexi in daycare and go out for breakfast, possibly shopping, maybe over to Wiregrass. And eventually, at some point on January 13th, they decided to go to the Cobb Grove Theater. They were going to see the movie Lone Survivor. That was going to start about 1:20 in the afternoon. Now, that's located at 6333 Wesley Grove Boulevard in Wesley Chapel here in Pasco County. So what you're going to learn is that they go to the theater. When they get there, they purchase their tickets. They then go inside to the concession stand and they buy some snacks. After that, they decide to go into the theater. Now, this theater is theater number 10, and what you're going to learn is that theater number 10 is a Cinebistro. It's a general theater and a Cinebistro, and you may know what a Cinebistro is, but basically it's an area of the theater where you can order food kind of like in a restaurant setting. You don't have to go to the concession stand. And this particular part of theater number 10 is separated from the general theater by a wall. In fact, there's a separate entrance. Now, what you're going to learn is that when Chad and Nicole Oulson decided to go into theater number 10, they were looking for some seats that were towards the back of the theater. That's where they like to sit. So they chose the row that was to the second to back last row. And they went over towards the middle. Nicole Oulson sat down, and on her right was Chad Oulson. Now, at this point in time, there wasn't that many people in the theater. People were still coming in. They had their snacks. They were talking. And at some point in time, one of them, doesn't matter who, one of them wanted some more snacks of some type of candy. Chad Oulson gets up, leaves the theater, goes back to the concession area. And of course, more and more people are coming into theater number 10 to see the movie. When Chad Oulson comes back, he sits down. Again, he's still on Nicole Oulson's right. And at some point in time during this, the defendant and his wife, whose name is Vivian Reeves, comes into the theater. Now, when they come into the theater, they decide to sit in the very back row. Now, there's a wall behind them, because behind that wall is where the Cinebistro area is. They go to the very back row, walk all the way across to the middle, and they sit down. Now, to kind of paint a picture for you as to where everybody's seated, and you're going to see this in video, and people are going to tell you where they were sitting. Picture this. So, in the very back row, you're going to have the defendant. He's sitting in the middle. Directly in front of him is Nicole Oulson. To Nicole Oulson's right is going to be Chad Oulson. Behind Chad Oulson is the defendant's wife, Vivian Reeves. So stated another way, to picture it a different way, you have the defendant in the very back row, basically in the middle. An entire row in front of him, and an entire seat over to the right is where Chad Oulson is sitting. That's the layout of the theater on this particular day when this shooting occurs. Now, what you're going to learn is that there were many people that came into the theater. In fact, at the beginning of jury selection, a long, fairly long witness list was read to you. And you heard from the court and you heard from us that you're not going to hear every single witness that's on that witness list, because there was a fairly large law enforcement response, and not everyone in the theater has relevant information. Some people became aware of the shooting afterwards. Some people didn't see anything. Some people didn't hear anything. And some of the law enforcement officers were there for basically security. So you're not going to hear from every single person. The people that you are going to hear from, they have different parts of the whole picture, meaning this. Some of the witnesses that you're going to hear from heard the beginning of what happened. Some heard the middle, some heard the end. Some saw the beginning. Some saw the middle, some saw the end. Some heard and saw basically everything. Now, you are going to learn that there is a video. And by video, I mean just that. There is a video and not an audio. The video comes from the Cinebistro area. There are two cameras inside of theater number 10 on opposite sides of the theater. Now, they were designed, as I mentioned, to capture the Cinebistro area, but they did capture some of the general part of the theater and did capture this shooting. Did capture people coming in the theater, did capture people leaving the theater, the defendant leaning in and talking to Chad Oulson, things of that nature. The video did capture that. Again, there's no audio. The audio is going to come from witnesses. Now, what are you going to learn? Well, people are going to tell you what the lighting environment was. So people in the theater are going to tell you the following. Now, don't pay particular attention to any single one-word description, because you can't adequately describe something in one word. In other words, to be pigeonholed to one word. For example, in everyday life, if someone were to tell you that someone was of a medium build, well, one person might think of that as a thin person, and another person might think of that person as a heavier person. But the description, when people elaborate, that's how you're going to be able to determine exactly what happened. So in this case, what are you going to hear from people that were in the movie theater? You're going to hear that at the time of the previews. Now, this shooting occurred during the time of the previews. So when I talk about the lighting conditions, it's the same during the time of the shooting. So what witnesses are going to tell you is that it was light enough for them to see in the movie theater. The lights weren't full, they weren't full house lights. It had been dimmed. So if you hear the words dim, dimmer, pretty dark, darker, that sounds like it's painting a different picture. But I submit the evidence is going to show you that when everyone came into the theater, their overall description, forget the one word, was that they could see. They could see aisles, they could see rows. They could see seats. They could see people in those seats, even at a distance. They didn't have any concern during these previews. Again, this was the time of the shooting, that they needed a flashlight or their phone to offer some light for them to navigate in the theater. It wasn't dark like when the movie starts. That's the lighting conditions at the time this shooting takes place. And that's the lighting conditions you'll learn about when Chad Oulson is on his phone. Now, what happens? The previews start. People are seated inside the theater. Again, you have the defendant in the very back row in the middle. In front of him is Nicole Oulson. Over to her right is Chad Oulson. Behind Chad Oulson is Vivian Reeves. The previews start, and there is a message that you should turn your cell phones off, basically. Now, here's what you're going to learn. Chad Oulson had his cell phone on. Now, by on, this is what I mean. Chad Oulson, the evidence will show you, he's not talking on his phone. He's not conducting a business transaction. He's not talking to a friend, a family member, not having a loud conversation. By on, literally the phone is on. That's it. The evidence will show you that there was a white light coming from the phone. That's how the phone was on. You're going to learn that almost immediately or very close after the time of that message, please be responsible, turn your cell phone off, whatever the message is. Very close in time to that, without really waiting, the defendant over here leans in to Chad Oulson and Nicole Oulson. Because the evidence will show you the cell phone had a light on it. Now, what you're going to learn is that this defendant leans all the way in, and it's going to sound silly when I say this, to Chad Oulson's personal space. And you're going to see this on video because it's captured. Not only is a witness going to talk to you about it, but it was captured on video. The defendant leans all the way in from his seat and basically gets back to the left ear of Chad Oulson. So the defendant's head is basically in their space. You're going to learn from a witness that the defendant's tone was kind of demanding. Turn your cell phone off. Now at that point, the evidence will show you they're kind of taken aback by this. Now, Chad Oulson did not turn his phone off. Now here's what you're going to learn what was going on that phone. He was looking at Facebook. Social media. There was a website that he was looking at through Facebook. And they had been looking at it. The evidence will show you, of course, that's no reason to shoot another man. But here's what you're going to learn. That the defendant leans all the way forward, tells Chad Oulson to turn his phone off. Chad Oulson doesn't turn his phone off right away. Now, in a perfect world, should Chad Oulson have turned his phone off? Yes, but the evidence will show you that you can't kill someone for that. Now, the evidence will also show you this, that the defendant waited a little bit, asked him again to turn his phone off, then got up to leave the theater. Now, the way he left the theater is going to be important for you to consider during the course of this trial. The overall attitude and demeanor of the defendant that's going to be described to you during the course of this trial is very important. Because one of the charges the defendant's been charged with is a crime called murder in the second degree. And all of these laws are going to be explained to you at the conclusion of the case when the judge gives you all of the instructions. But a part of murder in the second degree is that we have to prove that the defendant acted with ill will, hatred, spite, or evil intent. Ill will, animosity, bitterness, spite, annoyance. So the defendant's demeanor and his actions will play into whether or not there was ill will, hatred, spite, or evil intent. So here's what's important about when the defendant gets up to go tell the manager that this white light is bothering him during the movie previews. The defendant gets up, and as he goes out the aisle, he's mumbling to himself. Now, you're going to hear from a witness who's going to tell you that based on her life experiences, he appeared to be agitated and angry. The evidence is going to show you that he was. He was annoyed that Chad Oulson still had that phone light on. And he walks out, he's mumbling to himself. Now, as he's walking out fine, meaning this. Whenever anyone navigates through an aisle or a row in a movie theater, you necessarily have to move around people and it's kind of awkward. But he was able to do that. There's a video that you're going to see that shows him getting up and walking out of the theater. People watch him leave the theater. Remember, he's in the back row, goes all the way down the steps. There might be 13 rows. You're going to see pictures, you can count for yourself. Walks all the way down the ramp, all the way to the manager's desk. Now, when he's at the manager's desk, what happens? Well, when he's there, and again, there's no audio, there's going to be just a video. Watch his demeanor. Now, I don't mean to present to you, and I'm not painting the picture to you that when he's at the manager's desk, he's banging on the desk and screaming and demanding action, because he's not. But when we're talking about the demeanor of the defendant, the evidence will show you this ill will or spite. Watch his arms, watch his hands, watch his fingers, watch his facial expression. He's there for about 3 minutes, walks back into the theater, all the way up the ramp, around the corner, all the way back up to the back row, all the way across again into the middle. Now, the witnesses you're going to hear from are going to tell you this. They're going to tell you that the defendant did not appear to have any disability. He didn't have a cane, didn't have a walker, didn't have a wheelchair. The evidence will show you, and it sounds like a silly thing to measure, the defendant parked 133 yards away from the theater. Now, it sounds silly again. It's a football field and a third, but there's no handicap placards. The defendant's not handicapped. Wife didn't have a handicap placard. You're going to see video of the defendant as he purchases tickets. He's in the lobby area, in the concession area, walking to and from the theater. Now, why is that being brought up? Well, the evidence is going to show you this, and we're going to talk more about it in just a little bit. But the defendant gives a taped statement to law enforcement, freely and voluntarily waives his rights, and there's going to be a picture painted during this taped statement. And one of the things you're going to learn in this taped statement is the defendant states he's got arthritis in his back and his knees. Well, the evidence will show you that, let's say that's all true, it's very, very bad. The evidence will show you that's no reason to shoot and kill another person. However, when you see the actual pictures, meaning the video, and you listen to the witnesses, you're going to see he was completely fine. Now, what happens? When he walks back into the theater after speaking to the manager, coming back across the row. Now, it doesn't matter exactly when this happens. It's either as the defendant comes back into the theater, as he's sitting back down, or even some seconds after he's fully seated in his seat. Doesn't matter. But the defendant in this taped statement indicates that he reinitiates contact with Chad Oulson. Now, what's the evidence going to show you in this case? Chad Oulson was talking to someone earlier, and it was the person in the row in front. At no time will the evidence show you that Chad Oulson is volunteering to talk to the defendant. The defendant's always the one initiating the conversation. And as the defendant comes back, based on his own statement, he indicates that he reinitiates contact with Chad Oulson and tells him this. And here's something that's important you're going to learn during the trial. Chad Oulson did, in fact, turn off his cell phone. The phone was off when the defendant came back into the theater. The evidence will show you that the defendant could have just sat back down in his seat and everyone could have watched the movie and everything would have been fine. The phone was off, no problems. The evidence will show you that after there's a conversation, Chad Oulson is in his seat. Now, what the defendant states to Chad Oulson is, I see you put your phone away. I told the manager for no reason. Now, I submit the evidence will show you that there was no reason for that. Regardless, the statement was made. Based on the defendant's own statement, Chad Oulson turns around in his seat. Now, when you listen to the defendant's taped statement, pay very close attention to the words he chooses to use and the order in which he uses these words. The defendant states Chad Oulson turns around in his seat, and now Chad Oulson says some words to him. Now, in a perfect world, should that have happened? No. The evidence will show you you can't shoot someone for that. Chad Oulson does turn around and starts to have some words with the defendant. Mind your own business, leave me alone. There might be an F-bomb in there. And at some point, very close in time, because this is all happening fairly quickly, it's fluid, Chad Oulson stands up and continues, and he looks at the defendant. Chad Oulson's in his row. Remember, he's an entire seat in front of the defendant. An entire row in front of the defendant, and an entire seat over. And during this conversation, while he's standing up, he says, if it's any of your business, and there may be an F-bomb in there, I was texting my daughter. Now, the evidence will show you that he was on Facebook. The evidence will show you that under the law, whether he was on Zillow, buying a car, buying a house, checking the stock market, Facebook, texting, you can't shoot and kill somebody. It's irrelevant. I submit the evidence will show you he was just trying to get the defendant to leave him alone, and that's what he chose to say. Really doesn't matter. So the evidence will show you this. Chad Oulson is standing up. And as he's standing up facing the defendant, and you will see this on video, Chad Oulson reaches over with his right hand. And he reaches over into the defendant's lap and he grabs something. Now, this might sound silly. What does he grab? Does he grab a deadly weapon out of the defendant's lap? The evidence will show you absolutely not. Does he even grab a big tub of heavy popcorn? No. Here's what you're going to learn during this trial. Chad Oulson reached over with his right hand into the lap area of the defendant and grabbed a bag of popcorn. And he grabbed that bag of popcorn and he brought it back and he flicked it at the defendant. Now, the evidence will show you, of course, in a perfect world, should Chad Oulson have grabbed a bag of popcorn and tossed it on the defendant? Well, of course not. The evidence will show you can't shoot and kill another person over that. So the evidence will show you this, because there's a couple of things happening simultaneously at this point. So I want to break it down just a little bit. Chad Oulson stands up. He's facing the defendant, says something about texting his daughter. He reaches over, grabs the bag of popcorn, and flicks it. Doesn't pull it back, isn't using it like a bat, just flicks the popcorn on him. His hand is now coming back. At about that very same time, Nicole Oulson, remember, she's sitting in front of the defendant. She's starting to reach over with her left hand while this is happening. And in the process of getting up to say, honey, it's just sit down. So her hand's up. When her hand is up, and while Chad Oulson's hand's coming back from that popcorn toss, this defendant shoots. So taking a step back to kind of go over what happened. The evidence will show you Chad Oulson is sitting in his seat, turns around, says a few words to the defendant. Stands up, says a few words to the defendant, reaches in, grabs the popcorn, flicks it. Now, this is important to watch on the video because it goes back to arthritis, my back, my knees. What you're going to see on the video is the defendant, in an incredibly quick and swift maneuver, reaches his right leg out as he's leaning back, goes into his pocket to get his firearm that he's brought into the theater, pulls it out, and lunges forward to shoot Chad Oulson. The evidence will show you he's not back cowering in fear, but watch the manner in which he grabs this firearm, how quickly he is able to do it, how fluid he's able to do it, and how he lunges forward as he shoots. And why is that important? Well, to go back to the instruction of ill will, hatred, spite, or evil intent. The evidence will show you he was mad. Chad hadn't listened to him, and Chad threw popcorn on him. So, what happens next? After that, Chad stumbles. He begins to turn to go towards the aisle. He goes down a couple of seats. He's shot in the chest. He can't make it to the aisle even. He falls down on other people in the theater. Nicole Oulson's finger is almost shot off. It's almost severed from the bullet going through. She's screaming. Chad falls on the ground. There happen to be nurses and other people there that try to help Chad Oulson as he's laying on the ground with that bullet in his chest. Now, ultimately, of course, Chad Oulson dies. He's basically dead in the movie theater. There happened to be an off-duty deputy, not from the Pasco Sheriff's Office, but from another county in the theater. He gets up, you're going to see this on video, and he walks over to the defendant. The defendant has his gun on his lap. It's taken from him. The gun eventually is given to a sergeant at the Pasco Sheriff's Office. That gun is eventually sent to a place called the Florida Department of Law Enforcement. Now, during this trial, there's going to be some stipulations. Stipulations are agreed upon facts, so to speak. You get these, there's not going to be any other testimony on the matter. They're basically just accepted to. Now, one of the stipulations you're going to learn is that this firearm, the one the defendant used, it's a .380, was sent to the Florida Department of Law Enforcement. There was a shell casing there. Shell casing came back to that gun. Now, that's not an issue in this case because this is not a whodunit case. The important part of that stipulation is that this firearm, the one the defendant brought into the theater, was working properly. Didn't malfunction, wasn't an accidental shooting. This was an intentional and purposeful shooting. The gun was working fine. Now, People are working on Chad Oulson. This other deputy is with the defendant. People call 911. Now you can imagine when there's a 911 call about a shooting in a movie theater, there's a fairly large law enforcement response, and there was. And this is when the investigation begins. Now, people that were in the theater, they go to different parts of the theater. Some are in front of the screen, some are in the concession area, the lobby. Now, fire rescue was called. They had to what's called stage, meaning they had to wait for the movie theater to be secured before they could go in to try to help Chad Oulson. When the deputies came in, they made sure the scene was secure. They were trying to help Chad, dealt with the defendant. Fire rescue comes in, everyone goes to the hospital. Chad's life can't be saved. Eventually, Nicole has work done on her finger. Now, while deputies are there and people are in different parts of the theater, they hand out these blank forms. And sometimes they're called written statements. And people are not given any instructions on how to fill these out. They're just told to write down what you know. Now, of course, these are people in a theater who aren't law enforcement officers or lawyers, and they don't know how much to write or how little to write. Some people write one sentence, some write 10 sentences. It's basically just what they saw. Some people are going to tell you they're really upset by what they saw. And law enforcement used this as a first step in their investigation. Read those written statements, tried to figure out who they needed to talk to in some type of order. Who they were going to talk to that day, who they were going to follow up with later on. That's what happened with the written statements. Now, when people filled out these written statements, some people were near them, but no one was telling other people what to write or what to say. The witnesses that come into court are going to tell you what they personally heard and what they personally saw. That's it. Now, witnesses were interviewed. The defendant himself gave a statement, as I mentioned. He gave a tape statement. What the evidence will show you is that Chad Oulson was shot and killed over tossing popcorn. The defendant's statements are fairly consistent with other testimony and other evidence, including the video, up until the point of time of the shooting. The evidence will show you that the defendant's statement is not accurate as about what had occurred, based on what you're going to view during the course of this trial. So what did the defendant tell the police? The defendant tells the police that he went to the theater. Obviously he did. While he was in the theater, he saw Chad Oulson had his phone on. Now the defendant states he leaned forward and was being nice, asking him to turn the phone off. When Chad Oulson did not, he got up and he went to tell the manager. He came back. The defendant says that when he came back, he did talk to Chad Oulson, and he told him the statement that I represented before. I see you're not on your phone anymore. I went to tell the manager. He says, and again, the words he chooses are very important. You're going to learn that he was former law enforcement, so he knows the importance of the accuracy of words. He says that Chad turns around in his seat, and at that time, there's some words between them. He then indicates that Chad Oulson jumps up. Now, here's where I submit to you the tape statement has maybe two different statements, and this is where you're going to have to critically analyze this tape statement. It seems as though the evidence will show you that the defendant states nothing at all about the popcorn in the beginning, as if that event never took place. Now, you're going to learn with his glasses on, the defendant's got 20/20 vision. Can't really miss anything. What the defendant states is that Chad Oulson is coming over on top of him. Okay? So when you listen to the tape statement, at first it appears as though the whole popcorn thing never happened. Later in the tape statement, the defendant states when Chad Oulson jumped up, the popcorn fell almost immediately. Well, the evidence is going to show you that after the popcorn fell, that's when this defendant immediately took out his firearm and killed Chad Oulson. So the evidence will show you that tape statement's not exactly true. He says that when Chad Oulson jumps up, the popcorn fell immediately, and this is the picture painted in the defendant's tape statement. Here's what the evidence will show you. The defendant states he's in his seat. Behind Nicole Oulson, remember, Chad Oulson's one seat over to the right. One row down, one seat over. He's back in his seat, and he's got his left hand up, And he's yelling, no, 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 or whoa, whoa, whoa. This is the picture the defendant's going to paint on this tape statement. And he's back in his seat, and Chad Oulson is coming over the seat, and Chad Oulson is virtually on top of him. In his lap. Those are the words the defendant himself uses. Virtually on top of him, in his lap, and he's got his left arm out, and he's touching his arm or his shoulder, but he really believes he's touching Chad Oulson's chest because he's so far into him, into his row. And at that time, he has to straighten his right leg out, pull out that firearm, and kill him. The defendant states he's surprised he didn't shoot his left hand because his left hand was so far out when he took that shot. He's surprised. The evidence will show you that is not exactly what happened. There will be no witnesses that will come in here and tell you that happened. No one heard any yelling, screaming, any type of fight like that, life or death struggle. You're going to hear about a term called stippling during the course of this trial. Stippling, and this might be a really bad description of it, is when a firearm is fired, material comes out, hot material, and anything that's close in its way gets these embers, so to speak, and there's a burn mark on skin. Now, you will see stippling in this case. The evidence will show you there was stippling on Nicole Oulson's hand because it was in front of the firearm when her finger was almost shot off. You're going to see stippling on Chad Oulson's wrist because when he brought his wrist back after tossing that popcorn, you're going to see stippling all over there. But the evidence is going to show you there's no stippling on the defendant's left hand. The evidence will show you that's because his left hand was not out. No, 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 you got to get off of me. That's what the evidence is going to show you. Now, after the defendant fires the shot, there's some important words that people in the theater hear. And these are people that don't know each other, and these are people that are in different areas of the theater. And the defendant states some words to the effect of throw popcorn at me or throw popcorn on my face. Yet when you listen to the defendant's taped statement, it never really brings up the popcorn. The evidence will show you that's important for ill will and spite. And when you see the way he lunges forward with the firearm and makes that statement, you get a clearer picture of what was really going on in the theater on January 13th. The defendant states in this taped statement that while he's back with his arm out, yelling, no, 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 or whoa, 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 and Chad's virtually in his lap, he's struck on the left side of his face. Remember, you can hear the defendant, prior law enforcement. Words and choices of words are important. The defendant states in this taped statement that he's hit on the left side of his face. Well, witnesses are going to tell you they never saw that. And the evidence will show you that almost scientifically, physically, it's not possible. Because the evidence will show you that Chad Oulson was a row in front and a seat over to the right. And that it would be virtually impossible for him to do this hook that hooked all the way around from that distance, across an aisle, all the way across seats, and struck the left side of the defendant as he was all the way back with his left hand out. The evidence will show you that simply did not happen. The evidence will show you there was no injury, as if he was struck that hard, because the defendant in his taped statement, you will learn, says he was dazed. But he wears glasses. You will see there was no injuries of any markings for glasses of being hit that hard that he felt he had to kill another human being. At some point in the taped statement, the defendant indicates he thinks that maybe a cell phone was at play because he saw the blur of a screen. Now, you will learn that a cell phone was found in front of the defendant. And it was, in fact, Chad Oulson's cell phone. I submit the evidence will show you that it got there in one of two ways. One, because he was holding it in his left hand or his left side. And we know that because that was the side that was bothering the defendant. That when he stood up and he grabbed that popcorn, it fell over. Or, at the time he was shot, it was dropped. But the evidence will show you that no witnesses see anything remotely close to the defendant being hit with that phone, and there's no possible way that could happen. Now, another stipulation will be about this cell phone. This cell phone was also sent to the Florida Department of Law Enforcement. And there was some DNA testing done on this phone. Chad Oulson's DNA was on the phone, but not the defendant's. Now, you're going to see pictures. The defendant did have some redness on his left eyelid, possibly the most fragile part of the human body. But the evidence will show you he had his glasses on, and the reason that his left eyelid, only his left eyelid, was red was because after the shooting he was rubbing his face and rubbing his eyes, and witnesses will tell you that. He indicates he thinks there's something in his left eye. Paramedics check him out. There's nothing in there. They do a saline rinse. That's the end of the story. The defendant indicates in his taped statement that he second-guessed himself. He's sitting in the cruiser, and you're going to hear he says, "I'm second-guessing myself. Did he hit me?" This is the picture that's going to be painted for you during the course of this trial. The defendant also states, and I apologize for cursing at some point in this taped statement, and again, I apologize for the language, but oh shit, this is stupid. Now, for his actions, the defendant's been charged with 2 crimes: murder in the second degree and aggravated battery. Now again, all of the jury instructions are going to be explained to you at the conclusion of the case. Now, suffice to say, this is what murder in the second degree is. What we have to prove to you is Chad Oulson is dead. It was due to the criminal act of the defendant, and it was by an act that was imminently dangerous to another, demonstrating a depraved mind. Shooting someone at close range is an act imminently dangerous to another. That's not going to be an issue in this case. Did he do it with a depraved mind? That's where we fall back on the definitions that you're going to learn: ill will, hatred, spite, or evil intent. The other crime that the defendant's been charged with is aggravated battery. Now, going back to murder in the second degree, we do not have to prove to you that the defendant here intended to kill Chad Oulson, just that he intended to act, which he did. This is not a case where it's an accidental shooting. He did intend to shoot him, and he died. We just don't have to prove he intended to cause Chad Oulson's death. Now, aggravated battery, what we have to prove to you is that the defendant did intentionally, knowingly, and unlawfully touch or strike Nicole Oulson against her will. Now, obviously, he didn't do that with his hands. He did that by using a gun and firing a bullet. So it's the same analogy. Did he touch or strike her against her will? And did he use a deadly weapon? Yes, a firearm is a deadly weapon. The other way that we could prove aggravated battery on Nicole Oulson is, did he intentionally touch or strike her against her will? Yes, and cause great bodily harm, permanent disfigurement, or permanent disability? And the answer is going to be yes. You're also going to learn about an instruction called transferred intent. And basically what that means is if one person intended to do an act, meaning the defendant intended to do an act to one person, but ended up harming another. In other words, intending to shoot Chad Oulson, but harmed Nicole Oulson, be transferred intent. And that's how we get to the aggravated battery charge. Now, what is this case going to be about? Based on the facts that you were given at the beginning during jury selection and the defendant's own taped statement, it's apparent the defendant is claiming self-defense. So you're going to hear a lot about self-defense. At the conclusion of the case, you're going to get all of the self-defense jury instructions. The question will be not whether or not this was an accident, because there's no evidence of that. It was an intentional shooting. Whether or not the defendant was lawful, whether or not he was justified in using that deadly force and killing Chad Oulson. Now, this is basically what the self-defense instruction indicates. The use of deadly force is justifiable if Curtis Reeves reasonably, okay, and these are going to be important words here, reasonably believed that the force was necessary to prevent imminent death, he was going to die, or suffer great bodily harm, while resisting an attempt to commit a felony upon him. In deciding whether or not the defendant was justified in the use of force, the use of deadly force, you must judge him by the circumstances by which he was surrounded at the time the force was used. The evidence will show you those circumstances at the time that the force, meaning the shooting, took place, was that another individual had tossed popcorn on him. The danger facing the defendant need not have been actual. However, to justify the use of deadly force, the appearance of danger must have been so real that a reasonably cautious and prudent person, under those same circumstances, would have believed that the danger, and the evidence will show you the danger was popcorn was just thrown on him, could be avoided only through the use of that force. So the question for you will be this: would a reasonably cautious and prudent person that's 71 years old, because that's how old the defendant was, would a reasonably cautious and prudent person that's 71 years old, 6'2", 270 pounds, who's able to walk all around the movie theater, who has over 20 years of law enforcement experience, including 15 years on the Special Weapons and Tactics Squad, also known as SWAT, sitting inside a theater that by all accounts is going to be described as one in which you can see the environment, not pitch black like the movies, and not deafening loud, reasonably believe that the danger could only have been avoided through the use of shooting Chad Oulson? And the answer is going to be absolutely not. The evidence will show you there were some differences between Chad Oulson and this defendant on January 13th of 2014. Chad Oulson was 6'4", the defendant here is just 6'2", 2 inches difference. The defendant outweighed Chad by 65 pounds, but there was an age difference. The defendant was sitting an entire row back, an entire seat over. But the most important difference you're going to learn about during the course of this trial is that one of those two individuals brought a loaded firearm into a theater and shot and killed another person after popcorn was tossed on them. And that's this defendant. That's the one. At the conclusion of this case, we're going to ask you to find the defendant guilty of murder in the second degree. And we're going to ask you to find him guilty of aggravated battery. Not because we're asking you so, but because the evidence that you're going to see and hear during the course of this trial is going to tell you that that is the lawful and just verdict in this case. Thank you.
Thank you, Mr. Rosenwasser. Ladies and gentlemen, who's going to... Okay, we're going to take a break, yeah. Mr. Michaels will be doing his opening statement in a few moments, but I think it's appropriate to take a 10-minute recess. So remember my instructions during the recess: no research, no discussing the facts, etc. And the bailiff will, where are they going to go, to the jury pool room or just mill about and then return back here? Okay. All right. So as usual, you can mill about a little bit and then, but try to stay to this side of the courthouse if you would, and head back to the jury pool room, and Deputy Martin will come and get you. Any questions? All right. Thank you. You can be seated, thank you.
Your Honor, if I could just have a moment with Mr. Rosenwasser.
Sure. Uh-huh.
A moment with Mr. Rosenwasser, just going over some things to make sure we're in agreement on everything.
Okay. Oh, there you go.
Thank you.
All right, that's fine.
One other thing, we had a stipulation that Mr. Rosenwasser mentioned in his opening concerning DNA. We're going to discuss it. I'd like for the court to read it. I think it's proper coming from the court before I discuss it. May I approach?
Yes.
Can I have a copy here, Your Honor? What I've done is I've removed the back there. I put a line through the first paragraph because basically it says. Right.
Okay.
And if we can just start.
Stipulate, sure. And I have an instruction for that. Let's see. Here it is, 2.3, stipulations. When lawyers agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated fact, or at the moment, well, right now, that's the same ringtone that my husband uses from me. Gets my attention. Okay, so I'm going to read that instruction, then I'll read the stipulation.
All right. Thank you, Your Honor.
Mm-hmm. You ready when they are?
Mr. Escobar.
Yeah, bring them in. And you want me to read the stipulation right off the bat?
Jury's name in the courtroom, Your Honor.
Okay.
May I be allowed to request it, though?
You want me to, you want,
May I request it?
yes, when you're ready. Thank you, ladies and gentlemen. You can have a seat. Sorry I can't see most of you at the moment. I will be repositioning myself when the time comes, so I'll be sitting over there nearer to you. But for the moment, were all of you able to abide by my instructions during the recess? Nobody did any independent research or looked up anything or talked about the facts of the case? All right, very good. Then, in just a moment, I believe Mr. Michaels will begin his opening statement.
Thank you, Your Honor.
Thank you.
Your Honor, may I reposition myself?
You may.
Before I begin my opening statement, I'm going to request of the court, Your Honor, if you would please, read the stipulation concerning the DNA evidence in this case on the cell phone case and screen.
All right. And ladies and gentlemen, when lawyers agree that certain facts are true, that is called a stipulation of fact. You must accept stipulated facts as having been proven. However, the significance of these facts, as with all facts, is for you to decide. In this case, the stipulated facts that you must accept as true are as follows. The state and the defense stipulate to the following facts. The iPhone belonging to Chad Oulson, which was seized by law enforcement on January 13, 2014 from inside Theater Number 10, Cobb Theater at the Grove in Wesley Chapel, was tested by Mary Pacheco of the Florida Department of Law Enforcement Biology Unit for the presence of DNA material. The testimony of Mary Pacheco would establish the following results. 1. The DNA profile obtained from the iPhone black case, Exhibit AP13, demonstrated the presence of a mixture of at least 3 individuals. Due to the complexity of the mixture obtained from the iPhone black case, this data was not interpretable. Number 2, due to the limited nature of the DNA results obtained from the iPhone's black case screen, this data is insufficient for inclusion purposes but may be suitable for exclusion. Number 3, due to the limited nature of the results obtained, Chad Oulson can be neither included nor excluded as a contributor to the iPhone's black case screen. And number 4, Curtis Reeves is excluded as a source of the limited DNA results obtained from the iPhone's black case screen.
Thank you. Mr. Funderburg, bring up the display, please. Thank you. Okay, let's look at this. And why did I bring this up to start my opening statement? I brought this up because I want you to be able to put into context, to look at the form of the information you're getting from the prosecutor right off the bat at opening statement. What the prosecutor told you is simply not true. There is no stipulation, there is no evidence that the cell phone case or the cell phone case screen had the DNA of Chad Oulson on it. It's just not true. Let's look at this. It says, as the court read, DNA profile from the iPhone case. This is an iPhone case, black case that has a white cell phone in, a white iPhone. It's a case that has one of those screens that's kind of attached to the front for protection. So when they talk about the case, they're talking about the outside. When they're talking about the screen, they're talking about the front of the screen that a person would kind of scroll on. And so what this says is that, number one, presence of a mixture of at least 3 individuals. Due to the complexity of the mixture obtained from the iPhone black case, data was not interpretable. So based on what they got from the case, they couldn't interpret it. They have at least 3 people on it. So is it possible that if the evidence was properly preserved, that we would see Mr. Reeves's DNA, Curtis Reeves's DNA on that case as it hit him in the head? Of course it's possible. We'll never know because the way that this phone was handled was abominable. The sheriff's office didn't go in there and try to preserve it for any DNA evidence. They had a tech pick it up, manipulate the phone. Later on, they pull it out of a room again and try to turn it on to see whose it was, even though they knew who it was, who it belonged to. Due to the limited nature of DNA results obtained from the iPhone's black case screen, the front of it, this data is insufficient for inclusion purposes, but may be suitable for exclusion. Again, that doesn't tell you that Chad Oulson's DNA was on the phone. It tells you they can't tell you whose DNA was on the phone. Next page, please. Due to the limited nature of results obtained, Chad Oulson can be neither included nor excluded as a contributor to the black case screen. So what they're telling you is, not as the prosecutor told you, the evidence will show with a stipulation that, not true. That phone does not come back with Chad Oulson's DNA. We know it's his phone. His wife said, that's my husband's phone. The prosecutor and the state attorney's office and the sheriff's office, they all went in the phone. We know it's Chad Oulson's phone. But there's no DNA evidence that says his DNA was on it. It says Curtis Reeves is excluded as a source from the screen. That's all it says. So if a phone is going through the air, there are 2 sides to it, there are corners to it, the screen hits Mr. Reeves. Maybe. What if the back hits Mr. Reeves? Then certainly this isn't something that would be unusual. Not unusual. And so I bring this up to you because I think that it's important. That's all you're on the thing. I think it's important that you realize what it is you're being told here. From off the bat, you're told there's DNA on the phone. The other thing you're told, and you're going to see photos of it this morning, he's all the way in the other row. Chad Oulson is a whole row away from Mr. Reeves. Chad Oulson is a whole seat over from Mr. Reeves. You're going to see how very close they were. The theme of the prosecutor's case is that this was over popcorn. And what the prosecutor told you going in is, well, all I have to prove is that someone was shot, somebody died as a result of that shot, and their state of mind regarding that. That's not true. What the prosecutor has to prove, what the government has to prove, what the state of Florida has to prove in this case, beyond a reasonable doubt, that this was not justifiable. And when they talk about justifiable, the prosecutor told you, frankly, that's the law of circumstances. Under the same circumstances as Curtis Reeves, knowing what he knew. You can decide if it's reasonable if you were trained like Curtis Reeves. You're going to decide if it's reasonable if you're 71 years old. And although the prosecutor is telling you he walked all right, he did all this and that, you're going to hear from experts. And I'm going to talk to you a little bit more about that, about what the realities of the aging process are and what the realities of Curtis Reeves' condition was. So the framework of what you're to decide The state said, I'm going to ask you to come back. I can't ask you how to decide the case. You're the jury. You look at the evidence, and that evidence has to measure up beyond the exclusion of every reasonable doubt that Curtis Reeves did not act justifiably in protecting himself and protecting his wife who's sitting next to him. So since we're talking about Curtis Reeves and stepping to his shoes, let's think about that for a second. Number one, he's in a theater. The prosecutor's trying to make it seem, the same way they tried to make it seem about the DNA, that this theater is somehow lighted so you can see everything. A lighted movie theater with the previews on, imagine. They're telling you, don't believe. If somebody comes up with a description in one word, don't believe. No one can tell you what to believe and what not to believe. Their job is to put on the evidence, and you believe or don't believe. You're convinced by their evidence. Not because they're putting parameters on you, they're giving you rules. Don't believe this. If you hear one word, that's not true. Listen to the testimony, which you will. Let's talk about Mr. Reeves. All right. 27-year police veteran. Served his community for 27 years at the Tampa Police Department. Highly decorated officer. None more decorated in his years there. They thought so highly of him that at one point the powers that be with Tampa Police Department came to Curtis Reeves and said, we want you to start a SWAT team here, which he did. A responsibility he took very seriously, because that responsibility, that is a responsibility with other people's lives, his men's lives. And so he became trained, and he trained his men. He trained his men so that every day they could come home to their family. They can go home to their family and be safe. That's the training of the man that was in the theater with his wife. He was a superstar. And when he was there, he did everything, from patrol as a young man to homicide detective and everything in between. So he saw what it was like out there. He knows about danger. He knows what a fist can do to somebody as a young person or an old person. And by the way, the state's telling you, well, he's preventing great bodily harm. You're going to get a definition of that. That means something more than a bruise. It's not a bruise. That's what the judge is going to tell you. That's the law. After 27 years, the Tampa Police Department, Curtis Reeves is so highly thought of. When he retires from the police department, he gets recruited by Busch Entertainment, Busch Gardens, becomes their head of security. Now he's kind of in a job where he's dealing with the entertainment industry, the pleasure of the experience in the park industry, and he receives training for that. And you're going to see, we're going to talk about it in a little bit, some of the various courses he took. You're going to see a list of courses, and we'll talk about some of them. So throughout his years, he certainly learned how to assess a risk. He certainly knows how to spot danger. And so when he's in that theater, it's no different. That's his training and experience. That's something that you must consider before you make a decision, whether it was reasonable or not. And is this over popcorn? It is not. I'm going to show you some videos. And you're going to see that the prosecutor tries to paint this picture. They said Mr. Reeves is trying to paint the picture. By the way, he's a law officer. He should have known better. When he got arrested, he talked to them and he knew the words to use. Well, if he's a law enforcement officer, he also knows he has a Fifth Amendment right not to speak to the police. And he could remain silent and call his lawyer right away, but he didn't. So let's just talk about the fact that he's in a movie theater and they're saying it's over popcorn. You're going to see there was an attack before the popcorn was thrown. I'm going to show it to you. It wasn't just one attack, and it wasn't just popcorn being thrown. Put yourself in Mr. Reeves' seat. This is kind of a very unique situation in criminal law, because as jurors, you have to kind of put yourself in his shoes. After working at Busch Gardens, his body starts to break down a little more, continuing to break down, and he retired. Just couldn't do the job. Age caught up to him. And so he's off to retirement with his wife. Back in 2014, they were married for 47 years, his wife Vivian. They have 2 children, which you're going to hear from. Matthew, who is a police officer with Tampa, following in his father's footsteps. Jennifer Shaw, she's the daughter of Curtis and Vivian Reeves, and she has a child, their only grandchild. So Curtis and Vivian Reeves settle into retirement. They build a big house because they're hoping for a lot of grandchildren. They want to have room to entertain. And they decide to go to a movie on January the 13th, 2014. As you know, Lone Survivor. As he walks in, let's think about this 71-year-old man. The prosecutor's saying, well, he's 130 yards of football in the third away, football field in the third, I guess not counting the end zones, football field in a third away, and he walks there just fine. Doesn't use a cane, doesn't use a walker. You're going to hear from several witnesses. They're going to tell you about his physical condition. You're going to hear from Matthew, his son. Matthew's going to tell you about his father, a robust, vigorous man, as he sees them over the years being able to do less and less. Can't leather work, can't do woodworking, has trouble with his hands. They went on a hunting trip right before the movie, and Curtis Reeves couldn't pull back the compound bow. They were looking to getting him a crossbow. So he's seen his father deteriorate over the years. He knows that his father calls him up, Matt, I need the leaves taken off of the patio screen in the back. Jennifer, his daughter, is likewise going to testify how she's seen her father over the years deteriorate. She's seen him at one point, again, outdoors, going hunting, going fishing, camping, to a point where he can't take apart the paddles for a kayak. To the point where when he's on the floor playing with her daughter, with his granddaughter, he can't get up without help. Vivian Reeves is going to testify too. Now, she has her own health problems. She probably has ailments that are very serious. In fact, I know she has ailments that are very serious. She's going to tell you about them. She's being treated at Moffitt at the time. She had a knee replacement. Not in the greatest of shape. At any rate, she's going to tell you how she's seen the changes in her husband as well. How he needs to push himself off of the chair to get up when they're watching television. A little thing to some of us. Very important in this case. In fact, she's going to tell you that the day they were in the movie theater, the shoes that he was wearing, that Curtis Reeves was wearing, you didn't have to tie him with your hands because he had problems tying his own shoes. They had a little thing you pull, like you put on a preschooler, so they can tie their own shoes. You're going to hear from Dr. Donna Cohen. She's a PhD. She's a leading authority in the field of aging and the process of aging. She headed up the aging studies in University of South Florida. In fact, she started it. She's been doing it for over 50 years. She's an educator. She's going to testify as an expert. She's going to testify as an expert in the field of aging, the process of aging, and how it affects one's vulnerability. Because we can all think, well, he's walking all right, but really what's going on in his head? Police training, realization of vulnerability, it's important. We take for granted that we know about getting older. She's going to tell you scientifically, as an educator, how that works and why that works. You're going to hear from Dr. Michael Foley. He's a radiologist, a preeminent, nationally known radiologist. Why? Because the prosecutor's telling you, look at him, he can walk. You're going to see his x-rays and his MRI. And that radiologist is going to tell you about all the degenerative processes, the breaking down of his body that you can see on the x-ray. So he looks all right on the inside, on the outside, but not so good on the inside. He's got problems with his neck, his back, his shoulders, his hands, his hips, osteoporosis in his hips, all the way down. And so what does that do to an individual? Makes them more vulnerable. Also, it makes them more vulnerable to serious injury. So in that regard, you're going to hear from Dr. Bernard Adams. He's a pathologist. He used to be the medical examiner for Hillsborough County for 20 years, and now he's a pathologist on his own, and he's going to testify as an expert. The interesting thing about Dr. Adams, what he's going to do is he's going to show you on a model the most vulnerable part, starting off with the most vulnerable part of a human body is the head. So he's going to show you why it's vulnerable. He's going to tell you about older people. As you age, your brain shrinks, leaves more room in the skull, which makes you more prone to injury if you were to get a blow in the head, to the head. He's going to show you the changes in the bone structure of the neck, of the rib cage, that again make an older person, a person as they age, more vulnerable to serious bodily injury, to great bodily harm. He's going to talk about the fist as a weapon, the anatomy of it, how when you close your hand, it forms these points, your knuckles, and that becomes a dangerous weapon. You heard a little bit about what Curtis Reeves said. He got hit. He did. He has a red mark on his eye. The prosecutor's telling you somehow magically the phone flew around, this and that. Well, if it was so well lighted, you can see it on the video, why didn't everybody else see that happening? Why didn't everybody else see the popcorn grab? Because it was a dark theater. And the video, by the way, since I'm here, we're going to talk a little bit about the video. That system is not very good. It captures, it's infrared, it's motion detecting of a sort, so you're not going to see a clear video. In fact, our expert, Bruce Koenig, who again is a nationally renowned expert, he worked on the Monica Lewinsky case. They actually had him look over the JFK tapes again. He worked for the FBI, headed up their audio and visual department. He's still out there testifying as an expert. He will tell you about the resolution, how bad it is. I don't have it in front of me, so I don't want to give you the wrong numbers, but the numbers compared to what the iPhone was at the time. The iPhone had like 600 pixels, and this had like maybe 12,000, something crazy. And so you're going to see, you get a little piece of it today, a video that doesn't really give you good quality and doesn't show you everything. We would hope that it showed you. Let's talk about the facts of the case. You heard the prosecutor. Mr. and Mrs. Reeves, the retired couple, 71, she's 69. They go to the theater to watch a movie, a matinee. To watch a movie, to get the experience of a movie, to immerse yourself in the movie, to sit in your seats, a comfortable seat, have quiet around you, and be able to enjoy the experience of watching a movie in a movie theater. The plan is to meet their son Matthew there, the Tampa Police Department police officer. He's washing his truck, so he's a little late. He's going to meet them there. They walk in. As the prosecutor told you, it's true. That's true. They paid for his ticket. He walked in. They got a cold drink and a popcorn, which they share. Miss Vivian Reeves brings a little plastic baggie. Curtis Reeves gives her half the popcorn so they can each have their own. And they walk into the theater. Before they walk into the theater, Mrs. Reeves goes to the restroom. Now they walk into Theater 10. That's true. It is Theater 10. They walk into the theater. They're looking for 5 seats together. Why 5? Because they want to put their son together with mom and dad and have 2 seats, one on either side. And so they look, they see 5 seats together at the very back row. The very back row, as you were told, is the row that abuts what's called the Cine Bistro. There's a wall that's about 5 feet tall. Prosecutor told you about that, but an interesting fact about that wall is the chairs in the theater, they move back. They recline back slightly. Not, you can't lay down, but they recline back. With that wall behind the seat, you're not going to get as much movement on them. So Mr. Reeves sat there. Curtis Reeves, his wife, directly in front of Curtis Reeves. Already there is Nicole Oulson. Directly in front of Vivian Reeves is Chad Oulson. Now the prosecutor's telling you it's a whole row away. You'll see how close those seats are. They sit down to enjoy the movie. Curtis Reeves notices the phone is on. Yeah, he's not talking, but there's a white light. Prosecutor, there's a white light coming from the phone. We know he was on the phone. We know he was on Facebook. Doesn't matter if he was talking or not. There's a white light coming from the phone, and it's in Curtis Reeves' face. He asks him politely, would you please put the phone away? The answer he gets is, I was texting my effing daughter, do you mind? Something to that effect. Again, put yourself in the theater. You're retired. You're with your wife who's retired. You're there to have a movie experience. You ask somebody to put their phone away, and the response isn't bug off, it's none of your business, it's F off, I'm texting my daughter. And it continues, and it continues. Finally, Mr. Reeves does the right thing. He gets up. He's going to tell the manager. At this point, there is no thought that this person is going to turn into some hostile force, which happens later. At this point, it's just a loud guy who's cussing and ruining everybody's movie experience, including mine. Curtis Reeves walks down the aisle. Some people are saying he mumbled. They'll tell you, I don't know if he was telling his wife, I'll be right back. They don't know what he was saying. Some people don't hear the mumbling. Certainly he didn't kick anybody. He didn't hit anybody. You'll see the video for yourself. In fact, when I finish, I'm going to show you that part of the video. You hear from the prosecutor how he can just walk down the aisle. It's not a problem. It's really close. Watch the video. This is what you're going to see. I guarantee this is what you're going to see. As Curtis Reeves walks down the aisle, he has his hand up, and he's touching the wall for balance. You'll see him do it. He goes out to the desk, the service desk. The manager's there, a fellow named Thomas Peck. He's talking to this woman, Dawn Michelle Simpson. If the prosecutor doesn't call her, we will. She's there talking to the manager, telling him that she wants some movie posters to decorate her house or her TV room, some sort of thing like that. Mr. Reeves just waits. He doesn't interrupt her. He's not rude, and that's a testimony you can hear. You can hear the testimony from Dawn Michelle Simpson. You're going to hear the testimony from Thomas Peck that Mr. Reeves was polite and acted very nicely to please help me enjoy this movie experience I came for. Those aren't the words, but you get the idea. Mr. Reeves walks back into the theater, and I understand what the prosecutor's saying. The prosecutor's saying, well, he says in his statement that he initiated contact. Well, think about that statement. Here you have somebody who at this point is a suspect in committing a crime, not because it's a whodunit, as the prosecutor rightfully said. It should have been because the detective should have been thinking, was this a justifiable use of force? Never entered his mind. So they have Curtis Reeves sitting there, and they don't ask him these questions. They don't go back and re-interview him. So it's all right for witnesses that are going to be pro-government or say something that the state wants them to say, and you to believe them.
I would object to that. That's argumentative. It's not appropriate for us.
All right. I'll sustain. Move on.
The evidence will show that the state will present some witnesses that say things that's favorable to their side of the case. the evidence will show, and I know, because I just heard the opening statement of the prosecutor, that the prosecutor's argument is going to be that Mr. Reeves just made this statement during his interview, his voluntary interview. So you're supposed to believe one, that's what they're telling you, and then somehow not question the other, think maybe there should be more details to the other. Maybe the detective should have gotten back to Mr. Reeves and spoken to him. He was willing to do it. So what happens when Mr. Reeves gets back in, as he's coming to his seat, Chad Oulson turns around and says, "I see you turned me in." Words to that effect. Mr. Reeves at this point, seeing that Chad Oulson put his phone away, leaned forward and told him, "I'm sorry, if I knew you put your phone away, I wouldn't have gone to the management." You're going to hear from Nicole Oulson. She's going to tell you that from the first time Mr. Reeves asked Chad Oulson to put his phone away, they took it as a bossy way to ask. Why is that important? That's important because Chad Oulson gets annoyed. He was annoyed. That's what you're going to hear. That's going to be a description. Annoyed when Curtis Reeves asked him to put away his phone. But he's just not annoyed right then. He stays annoyed. Think of this. He's stewing like a pressure cooker ready to pop. Because when Mr. Reeves gets back, he's still annoyed. Mr. Oulson gets up.